You found the podcast, Go Beyond the Brief, where we take a deep dive into the societal currents shaping our lives. Together, we'll explore the often unseen forces at play. We'll examine the research, dissect the data, and most importantly, if you're seeking to understand what's shaping our society,
a really significant
this
legal
is the
clash.
place.
The United States versus the city of New York.
Yeah, it's a major constitutional showdown. The federal government is directly challenging New York City's, well, its immigration enforcement policies.
The ones people often call sanctuary provisions.
Exactly. And we're working directly from the source here, the actual legal complaint the U.S. filed.
Right. It's filed against the city, the mayor, the council, and key departments like corrections, the NYPD, probation.
So our mission really is to unpack what specific city laws are under fire.
And understand the federal argument. They're saying these local laws are basically void because of the supremacy clause in the Constitution. Federal law trumps local law here, is the claim.
And the complaint jumps right into the deep end. It immediately references President Trump's declaration of a national emergency at the border back in January 2025.
And Executive Order 14,159, setting the stage that this is about public safety threats from certain illegal aliens, according to the filing.
It really frames the whole thing as an urgent matter.
So let's start where the complaint starts with the public safety context. The federal government uses some, frankly, tragic recent events to argue that NYC's policies are failing operationally.
Yeah, they use these specific examples to build their case. It's a powerful narrative tool in a legal document.
They kick off with that awful shooting of an off-duty CBP officer. Fort Washington Park, July 2025. Allegedly ambushed by 2 illegal aliens.
And the complaint zeroes in on the how. How did this happen?
It focuses on one of the alleged shooters having a prior arrest, right? April 2024, grand larceny.
That's the crucial link they're drawing. IC, Immigration and Customs Enforcement, put an immigration detainer on him while he was in city custody.
Which is basically a request to hold him so IC can pick him up.
Simple request, hold him for us. But the NYC Department of Correction, the DOC, didn't honor it. They cited city rules.
And released him. So the federal argument is the city's policy directly resulted in him being free to allegedly commit this later crime against a federal officer.
Exactly. And they don't stop there. They bring up another really disturbing case to reinforce the point.
Which one is that?
An alien arrested April 2023 for sexual assault.
Oh.
Held at Rikers Island. Again, ICE lodged a detainer.
And again, the DOC didn't honor it.
Ignored it. Released him in June 2024.
And then just 2 months later.
Arrested again. First-degree rape of a homeless woman.
Wow. And the complaint actually quotes Mayor Adams on this.
It does. Mayor Adams, who, remember, is a defendant here, he's quoted saying that specific individual was the poster child of what's wrong with not doing that coordination with ICE.
That really highlights the tension, maybe even conflict, within the city's own leadership about these policies.
Absolutely. And now the federal government argues there's even stronger federal law backing them up.
They mentioned the Lake and Riley Act.
Yes, Senate Bill 5 from this year, 2025. It mandates federal detention for illegal immigrants accused of certain serious crimes, theft, assaulting law enforcement, crimes causing serious injury.
So the feds are essentially saying, look, Congress has spoken directly on detaining these individuals.
And your local laws, New York City, are actively getting in the way. That's the core of the preemption claim. If federal law says detain and local law stops it, the local law has to give way.
Okay, so that sets the stage. The human cost argued by the feds. Let's get down to the mechanics of the policy clash. It seems to boil down to 2 main things: detainers and sharing information.
That's right. Let's start with the detainer. What is it?
For anyone listening who isn't familiar, can you break that down?
Sure. An ICE detainer. It's basically a formal request. It asks the local police or jail to do 2 things.
Okay.
1, tell ICE before you release someone they suspect is removable from the country. And 2, hold that person for up to 48 hours, not counting weekends or holidays.
Just long enough for ICE to get there and take custody.
Right. It's designed for a safe, orderly transfer inside a secure facility and not out on the street.
Okay, but the numbers cited in the lawsuit about NYC's compliance, they're pretty stark. It goes beyond just not cooperating. It looks like active resistance.
Oh, absolutely. The complaint uses the city's own data, and it shows, well, a near total collapse in cooperation. In fiscal year 2024, the DOC honored only 4% of ICE detainers.
4%. And you compare that to What was it before?
Back in fiscal year 2010, the complaint notes, DOC honored 80%.
80 down to 4. That's not just a slight dip, that's a massive policy shift made real.
It's clearly deliberate. And look at the NYPD, the police department, their cooperation, even lower.
How low?
They haven't honored any ICE detainers since fiscal year 2017, 0. They only honored 7 total between 2013 and 2016, then stopped completely.
And this lack of cooperation, ICE argues, forces their hand, forces them out into the community to make arrests.
Which they say is far more dangerous and resource intensive.
Okay, so that's the physical holding part to detainer. But the lawsuit also hits hard on blocking communication, sharing information. And there's a specific federal law about that, right? 8 U.S.C. Section 1373.
Yes, Section 1373. Crucial piece of this. Congress passed it back in 1996 specifically to stop states and localities from gagging their own officials.
Oh, did that say?
It explicitly says no state or local government can prohibit or restrict any official from sending or receiving information about someone's citizenship or immigration status with federal immigration authorities, DHS.
So Congress tried to guarantee that information flow.
They did. They wanted to ensure local observation wasn't walled off from federal enforcement.
But the NYC Administrative Code seems to run right into that. Section 91318K2. What specific information is the city telling its employees not to share?
It's incredibly specific. The city law forbids DOC staff from using any city time or resources to tell federal immigration authorities about an inmate's, basic custodial information.
Like what?
Like whether they're even incarcerated, their upcoming release date, even their court appearance dates.
Wait, even court dates? So ICE can't even plan to be there?
That's what the feds are arguing. If ICE doesn't know when someone's getting out or where they'll be in court, the whole system of detainers and coordinated enforcement just breaks down.
It sounds like that local law is designed specifically to block the very communication Section 1373 requires.
That's exactly the federal government's argument, pure obstruction.
Let's trace this back a bit. NYC didn't just become a sanctuary city overnight. This has a history. How did we get to this point of near-zero cooperation?
It goes way back. You can trace the roots to Mayor Ed Cox's Executive Order 124 in 1989.
89, wow.
Yeah, that was one of the first big moves. It barred city officials from sharing information with federal immigration authorities unless there were very specific, limited circumstances.
And then Congress reacted to moves like that nationwide with those 1996 laws we mentioned, including Section 1373.
Exactly. Congress said, hold on, immigration is federal territory, you need to share information.
And didn't the city fight that back then?
Oh, yes. NYC actually sued the United States over those federal laws. They argued it infringed on their local autonomy.
How did that turn out?
They lost. The Second Circuit Court of Appeals ultimately sided with the federal government. The court said, essentially, that while the feds couldn't commandeer state resources entirely, states and cities couldn't forbid all voluntary cooperation and information sharing. Federal authority in immigration was affirmed.
So the feds won that round on information sharing back in the 90s. How did the city manage to ramp up restrictions again, leading to where we are now with this lawsuit?
They shifted tactics. Instead of just blocking information, they focused on making it practically impossible to honor the detainer request itself.
Oh, okay.
And the crucial moment was 2014. That's when the city council passed local laws 58 and 59. These drastically expanded the sanctuary rules. This is really the legal core of the current fight.
What was the killer change they made in 2014?
They put in a new 2-part test for honoring any ICE detainer. Super restrictive.
Okay. What were the 2 parts?
First, the detainer request absolutely had to be backed by a warrant signed by an Article 3 federal judge or magistrate judge.
Article 3 judge. That sounds serious. Like for criminal cases.
Exactly. And second, the person had to have been convicted of a specific violent or serious crime within the last 5 years, or they had to be on the federal terrorist watch list.
Okay, let's pause on that warrant requirement. An Article 3 judicial warrant. Why is demanding that type of warrant such a big deal? Why does it effectively shut ICE down?
Because immigration enforcement, for the most part, is handled under civil law, not criminal law. ICE uses what's called a civil administrative warrant for removal proceedings.
So that's different from a criminal warrant.
Totally different. An administrative warrant is an internal government form signed by an authorized immigration official, not a judge. Congress specifically authorized ICE to use these administrative warrants to take custody for civil immigration violations. It functions more like a notice or an order within the executive branch.
But an Article 3 judicial warrant, That's what you need for a criminal arrest or search, right? Signed off by a neutral judge based on probable cause of a crime.
Correct. So, by demanding a criminal-style judicial warrant for a civil immigration hold, NYC set a bar that ICE simply cannot meet in most cases. ICE doesn't get judicial warrants for routine removals because it's not a criminal process.
So the city is demanding a tool that isn't used or even appropriate for this function.
Precisely. It's like asking the health inspector to get a criminal search warrant just to check a restaurant's kitchen. Because ICE can't produce this specific type of warrant, their congressionally approved administrative warrants become useless in NYC jails.
Which explains the plunge to 4% compliance.
It effectively eliminated compliance for almost everyone, and the city knew it. The complaint mentions that the city's own analysis back in 2014 predicted this change could bring the percentage of detainers to virtually zero.
So it was a calculated move to achieve non-compliance through procedural hurdles.
That's the argument. And it wasn't just the warrant. The narrow 5-year window for violent or serious convictions also excluded many people ICE might consider priorities, maybe someone with older convictions or someone with pending serious charges, but no conviction yet.
And the complaint points to other city rules that create obstacles too, right? Beyond just the warrant thing.
Yes, several others. There's NYC Admin Code Section 10178. It basically says city money and city employee time can't be used to help with immigration enforcement.
Which sounds very broad.
It is. And then there's Section 9131, too, which gets really specific. It flat out prohibits federal immigration authorities from having an office on any Department of Correction property if it's for civil immigration enforcement.
No ICE office space on Rikers Island, for example, to process civil cases.
Correct, which leads directly to that recent clash within the city government itself.
Ah, right.
Yeah.
The mayor versus the city council earlier this year.
Exactly. Over Executive Order 50. That was back in April 2025. First Deputy Mayor Sheena Mastro tried to authorize some federal agencies, including an ICE division, to have office space on DOC grounds.
But there was a catch, wasn't there?
A big one. It was strictly limited to criminal enforcement only, not civil removals. It looks like the mayor's office trying to find a tiny loophole, maybe cooperate on cross-border crime, without touching the sanctuary law protections for civil immigration.
An attempt to thread the needle, maybe satisfy both the feds on crime and the council on sanctuary.
Possibly. But even that tiny step towards cooperation was too much for the city council.
They sued the mayor's office.
Immediately. Argued it violated the spirit, if not the letter, of the sanctuary laws. And they won, at least initially. A judge granted a preliminary injunction in June 2025, stopping the executive order cold.
And the council speaker was pretty clear about their motives.
Very clear. Speaker Adrienne Adams said the council would use its power to protect New Yorkers from the Trump administration's harmful agenda. It shows a deep political commitment in the council to maximum non-cooperation, even if the mayor seems to acknowledge some downsides.
So from IC's perspective, what's the practical result of all these layers of non-cooperation? The ignored detainers, the info blocking, the office bans.
Well, Tom Homan, the former acting IC director, is quoted in the complaint, along with other ICE statements. They all say the same thing. It's dangerous and expensive.
Why dangerous?
Because if they can't do a simple, safe transfer inside a jail, they have to find and arrest these individuals out in the community. They call them at-large arrests.
Which means tracking people down on the street.
On the street, at their homes, at their workplaces. Think about it. It takes way more resources, surveillance, planning, and Homan argues it's inherently riskier.
Riskier for whom?
For everyone involved. The ICE officers, the person being arrested, and potentially the public nearby. An arrest in a controlled jail setting is predictable. An arrest out in the open can be unpredictable, chaotic, potentially confrontational. It turns a routine transfer into a potentially high-risk operation.
Okay, so we've covered the context, the specific policies, the history, the internal city conflicts, and the operational impacts. Let's bring it all together. What are the core legal arguments the U.S. government is making in this lawsuit? The big so what? Why do they say these NYC laws are illegal?
There are basically three main claims, all rooted in the Supremacy Clause of the Constitution, the idea that federal law is supreme.
Okay, claim number one.
Violation of the Supremacy Clause through preemption. This is the bedrock argument. The U.S. says these NYC laws create a direct obstacle to enforcing federal immigration law. They specifically block the communication Congress required in Section 1373, and they make it impossible for ICE to use the administrative warrants Congress authorized. When local law makes federal law impossible to execute, it's preempted, meaning it's void.
So NYC is standing in the way of federal functions. Claim 2.
Unlawful discrimination against the federal government. This one focuses on unequal treatment. The argument is NYC treats federal immigration authorities differently and worse than other law enforcement agencies.
How so?
Well, the NYPD and DOC cooperate all the time with the FBI, the DEA, state police, other local agencies sharing info, providing access, working together. But they have specific rules banning that same cooperation, that same access for ICE civil enforcement. The feds say that's discrimination based solely on the agency's federal immigration mission.
Singling out ICE for non-cooperation. And the third claim.
Unlawful regulation of the federal government. This goes right back to that Article 3 warrant demand. By telling ICE what kind of warrant it must get, a judicial one, not its authorized administrative one, and by restricting ICE's access to detainees based on that demand, NYC is effectively trying to regulate how the federal government performs its duties.
Dictating terms to a federal agency about its own congressionally authorized procedures.
Exactly. They're saying NYC is unlawfully interfering with federal officers carrying out their duties under the Immigration and Nationality Act, like the duty to inspect arriving aliens.
So when you boil it all down, this deep dive really lays bare this long-running tension. Federal government asserting total control over immigration versus a major city using, well, every legal tool it can find to limit its participation in that enforcement.
It's a fundamental conflict over power, policy, and information, and that information control piece seems absolutely central.
Yeah, you mentioned earlier the complaint alleges that in that Coney Island rape case, the DOC said they had no record of the ICE detainer, even though ICE insists they lodged one.
Right. Which brings us to that final thought for you, the listener, to really chew on. The complaint suggests NYC policies go beyond just ignoring detainers. It implies they might prevent city employees from even documenting a detainer or an administrative warrant in an inmate's official file.
So the record itself is kept clean of the federal interest.
Potentially. Think about the implications. If a legally valid detainer exists, but it's intentionally kept out of the internal records, what happens next?
If that person gets transferred to another facility or goes to court.
The next agency, the next official, has no way of knowing about the ICE hold. They can't act on it because, according to the file in front of them, it doesn't exist.
So the question becomes, is controlling internal record keeping in this way just passive non-cooperation respecting local rules? Or does it cross a line into actively, deliberately obstructing federal law enforcement by manipulating the information flow itself?
Where does that line sit? That's a really thorny legal and practical question at the heart of this case, defining the limits of state and local resistance to federal policy.
Definitely something to think about as this high-stakes legal battle unfolds.